Question 1. In a situation where formal requirements conflict with emergency medical needs, a hospital faces a dilemma regarding its legal obligations under EMTALA. A patient experiencing a severe cardiac event arrives at a private hospital's emergency room. The hospital, however, does not have a cardiology department and is not equipped for advanced cardiac interventions. The hospital's emergency physician determines that the patient requires immediate cardiac catheterization, which is available at nearby hospital. What is the hospital's legal obligation under EMTALA before transferring the patient? A. The hospital must provide an appropriate medical screening examination but is not required to stabilize the patient before transfer. B. The hospital must stabilize the patient to the best of its ability and ensure that the transfer meets the statutory requirements for appropriateness. C. The hospital can transfer the patient immediately after informing the receiving hospital without additional formalities. D. The hospital can refuse to treat patient since it does not have a cardiology department and direct the patient to the other hospital. Answer. B. The hospital must stabilize the patient to the best of its ability and ensure that the transfer meets the statutory requirements for appropriateness. Explanation. Under the Emergency Medical Treatment and Labor Act EMTALA, hospitals that participate in Medicare and have emergency departments are required to provide a medical screening examination (MSE). The hospital must determine whether an emergency medical condition exists. Stabilization requirement. If an emergency condition is identified, the hospital must provide treatment to stabilize the patient within its capabilities before transfer. Appropriate transfer. If the hospital lacks the necessary resources, the transfer must meet the following conditions. The receiving hospital must accept the patient. The transfer must minimize risks to the patient's health. Medical records must be sent with the patient. The transfer must be executed with qualified personnel and equipment. Option is incorrect because stabilization is required before transfer unless the risk of delay outweighs the benefit. Option C is incorrect because transfer cannot occur without ensuring compliance with EMTALA's transfer provisions. Option D is incorrect because hospitals cannot refuse care due to lack of specialized department. They must first stabilize the patient before transfer. Failure to comply with EMTALA can lead to fines, exclusion from Medicare, and legal liability. Question 2. When developing a solution that must address opposing needs, a healthcare administrator at a major hospital system is considering a merger with another hospital to expand services. However, concerns arise regarding potential antitrust violations under the Sherman Act. Under what circumstances would the merger violate antitrust laws? A. If the merger substantially reduces competition in a specific healthcare market and leads to increased prices or reduced services. B. If the merger increases efficiency and expands healthcare access even if competition is reduced. C. If the merger is approved by state regulatory agencies, federal antitrust laws do not apply. D. If the merger is between nonprofit hospitals, it is automatically exempt from antitrust scrutiny. Answer A. If the merger substantially reduces competition in a specific healthcare market and leads to increased prices or reduced services. Explanation. The Sherman Antitrust Act and Clayton Act regulate mergers and acquisitions in healthcare to prevent anti-competitive behavior. Courts analyze whether a merger substantially lessens competition. If two dominant hospitals in a geographic area merge, patients may have fewer choices, leading to increases or service reductions. Creates a monopoly. If a hospital system gains excessive control over the market, it can impose unfair pricing and restrict patient access. Reduces innovation and quality. Less competition often results in a decline in service quality. Option B is incorrect because increased efficiency does not automatically justify anti-competitive behavior under antitrust laws. Option C is incorrect because state approval does not preempt federal antitrust enforcement. Option D is incorrect because non-profit hospitals are not exempt from antitrust scrutiny if their actions reduce competition. Courts assess mergers under the Federal Trade Commission Act, and cases like FTC v. Advocate Healthcare highlight how healthcare mergers must comply with competition laws. Question 3. During an emergency response where multiple areas are impacted, a large-scale data breach occurs at a hospital affecting thousands of patient records. The hospital's compliance officer must determine its obligations under HIPAA's breach notification rule. Which of the following steps must the hospital take to comply with HIPAA? A. Notify affected individuals within 30 days. Notify the Department of Health and Human Service (HGS) immediately and issue public press release. B. Notify affected individuals within 60 days. Report the breach to HHS if it affects more than 500 individuals, and notify the media if required. C. Notify affected individuals within 90 days. Notify HHS if requested during an audit. Notify law enforcement instead of the public. D. The hospital is not required to notify patients if the breach was accidental and caused by an internal employee mistake. Answer. B. Notify affected individuals within 60 days. Report the breach to HHS if it affects more than 500 individuals, and notify the media if required. Explanation. Under the Health Insurance Portability and Accountability Act (HIPAA) breach notification rule, covered entities must follow strict reporting guidelines in case of a data breach. Notification to individuals. Affected individuals must be informed without unreasonable delay and no later than 60 days after discovery of the breach. Notification to HS. If the breach affects 500 or more individuals, it must be reported to HHS immediately, within 60 days. If fewer than 500 individuals are affected, the breach must be reported at the end of the calendar year. Media notification. If more than 500 individuals in a single jurisdiction are, local media must be informed. Option is incorrect because the rule allows up to 60 days, and a public press release is only required for breaches affecting more than 500 people in one state. Option C is incorrect because delaying notification beyond 60 days violates HIPAA, and law enforcement does not replace patient notification. Option D is incorrect because accidental breaches still require notification unless they meet HIPAA's low probability of compromise exception. Non-compliance with HIPAA can lead to substantial fines, civil lawsuits, and reputational damage for healthcare providers. Question 4. In a high-stakes environment where multiple challenges arise regarding patient data security, a large hospital system is expanding its telemedicine services. The hospital has partnered with third-party vendors to provide remote consultations and has implemented cloud-based electronic health record (EHR) systems. However, a recent cybersecurity audit found vulnerabilities in the way protected health information (PHI) is being transmitted between the hospital and the third-party vendors. Some physicians also access patient records using personal devices, raising further security concerns. Given HIPAA's privacy and security rules, what legal obligations does the hospital have, and how should it address these issues to remain compliant? A. The hospital must conduct risk assessment, ensure encryption of PHI in transit, and require all physicians to use hospital-approved devices for access. B. The hospital is only responsible for its own cybersecurity measures and does not need to regulate how third-party vendors handle PHI. C. Since physicians have the right to access medical records, the hospital cannot impose restrictions on how they access patient data, even if they personal devices. D. The hospital can avoid liability if it informs patients of potential security risks and obtains consent before transmitting their PHI through telemedicine services. Answer A. The hospital must conduct a risk assessment, ensure encryption of PHI in transit, and require all physicians to use hospital-approved devices for access. Explanation. The Health Insurance Portability and Accountability Act (HIPAA) security rule requires covered entities to implement administrative, physical, and technical safeguards to protect electronic protected health information (FI) SS 164.306. The hospital must conduct risk analysis to identify vulnerabilities and take appropriate action SS 164.308A. 1 A. Encrypting FI during transmission is essential under the security rule SS 164.312 E1. The use of personal devices for accessing PHI must be addressed through access controls and security policies to prevent unauthorized disclosure. Business Associate Agreements (BOS) must also be in place with third-party vendors SS 164.314A. Option B is incorrect because HIPAA requires covered entities to ensure that business associates comply with security measures. Option C is incorrect because covered entities can impose restrictions on access to protect PHI. Option D is incorrect because patient consent alone does not absolve hospital from implementing appropriate security safeguards. Question 5. During a comprehensive review of a process that needs improvement, a health insurance company is evaluating its fraud detection system for Medicaid claims. The company has noticed an increase in suspicious claims involving unnecessary medical procedures and false diagnoses. Under federal fraud and abuse laws, what are the company's obligations and what legal risks do healthcare providers face when engaging in fraudulent billing practices? A. The company must report suspected fraud to the federal government, and providers who submit false claims can face penalties under the False Claims Act. B. Fraudulent billing is civil offense but does not lead to criminal charges against providers. C. If provider mistakenly submits incorrect claims, they are automatically exempt from penalties under the stock law and anti-kickback statute. D. As long as healthcare provider bills within industry standards, they cannot be held liable for fraud, even if unnecessary procedures are performed. Answer A. The company must report suspected fraud to the federal government, and providers who submit false claims can face penalties under the False Claims Act. Explanation: the False Claims Act FCA 31 U.S.C. SS 3729 imposes civil and criminal penalties on individuals and entities that knowingly submit false or fraudulent claims to government healthcare programs like Medicaid. Violators may face treble damages, 3 times the fraudulent amount, and civil penalties per false claim. The Anti-Kickback Statute Acts 42 U.S.C. SS 1327 makes it illegal to offer, pay, solicit, or receive kickbacks for patient referrals in federal healthcare programs. The Stock Law, Physician Self-Referral Law 42 U.S.C. SS 1395 prohibits physicians from referring patients to entities with which they have financial relationship unless exceptions apply. Option B is incorrect because fraudulent billing can lead to criminal prosecution. Option C is incorrect because mistakes can still result in penalties unless the provider can prove they acted in good faith and corrected errors. Option D is incorrect because performing medically unnecessary procedures can still constitute fraud. Question 6. When developing a solution that must address opposing needs, a state legislature is considering a law to require hospitals to provide emergency medical care to uninsured patients while also ensuring financial sustainability for healthcare providers. The proposed law seeks to balance EMTALA's emergency care requirements with the financial constraints of hospitals. Which of the following best describes how EMTALA applies and what considerations should be taken into account? A. Hospitals must provide emergency medical treatment regardless of patients' ability to pay, but they can transfer patients immediately to another facility if they lack insurance. B. EMTALA requires hospitals to screen and stabilize all patients with emergency conditions, and they can only transfer patients under specific conditions. C. Hospitals can refuse treatment to uninsured patients as long as they provide list of alternative health providers. D. The financial burden of providing emergency care under EMTALA can be shifted entirely to state governments. Answer B. EMTALA requires hospitals to screen and stabilize all patients with emergency conditions, and they can only transfer patients under specific conditions. Explanation: the Emergency Medical Treatment and Active Labor Act EMTALA 42 U.S.C. SS 1395 requires Medicare participating hospitals to provide medical screening and stabilize emergency medical conditions regardless of patients' insurance status. Hospitals cannot transfer patients unless they have been stabilized or the transfer is medically appropriate, e.g., patient requires specialized care at another facility. Option is incorrect because hospitals cannot transfer uninsured patients solely based on their inability to pay. Option C is incorrect because hospitals cannot refuse emergency care based on insurance status. Option D is incorrect because EMTALA obligations fall on hospitals, not state governments. Question 7. In an environment where different components must interact, a biotech company is conducting clinical trials on a new gene therapy treatment. The trial involves human subjects and is being overseen by an institutional review board. What legal and ethical obligations must the company follow to ensure compliance with research regulations? A. Obtain informed consent from participants, ensure approval, and comply with federal research protections. B. Only obtain approval as informed consent is not required for experimental treatments. C. As long as participants sign a liability waiver, the company is exempt from federal research regulations. D. Clinical trials do not require oversight if the research is privately funded. Correct answer: A. Obtain informed consent from participants, ensure approval, and comply with federal research protections. Answer A. Obtain informed consent from participants, ensure approval, and comply with federal research protections. Explanation: clinical trials involving human subjects must comply with federal research regulations under the Common Rule 45 CFR Part 46 and FDA Regulations 21 CFR Parts 50 and 56. Research involving human participants must obtain informed consent. 46.116 Ensuring participants understand risks, benefits, and procedures. Be approved by an SS 46.109, which evaluates ethical considerations and ensures participant protection. Comply with federal protections, such as those under the Belmont Report, which emphasizes respect for persons, beneficence, and justice in human research. Option B is incorrect because approval alone does not eliminate the requirement for informed consent. Option C is incorrect because liability waivers do not exempt researchers from federal regulations. Option D is incorrect because all human subject research, regardless of funding source, must comply with ethical and legal guidelines. Question 8. In a high-stakes environment where multiple challenges arise regarding compliance with employment laws, a multinational corporation is facing lawsuits from employees alleging wage theft, misclassification as independent contractors, and failure to provide legally required benefits. The company operates in multiple states, each with varying labor laws, in addition to federal regulations. What legal obligations does the corporation have under the Labor Standards Act (FLSA) and other labor laws, and how should it address these claims? A. The company must comply with both federal and state wage laws, classify workers correctly, and provide benefits required under the law. B. As long as the company follows federal wage laws, it does not need to comply with state-specific labor laws. C. Independent contractors are never entitled to benefits, so misclassification does not pose a legal risk. D. Employees must take their claims to arbitration, and the company is obligated to change its wage policies unless a court orders it to do so. Answer A. The company must comply with both federal and state wage laws, classify workers correctly, and provide benefits required under the law. Explanation. The Fair Labor Standards Act (FLSA) 29 U.S.C. SS 201 establishes minimum wage, overtime pay, and child labor standards for employees in the U.S. However, states can enact stricter wage laws, which employers must also follow. Worker classification is governed by the Department of Labor DOLCER NIARAS guidelines, and misclassification can result in back pay, penalties, and tax liabilities. Misclassification. If workers are incorrectly classified as independent contractors instead of employees, they may be denied benefits, overtime pay, and job protections. Dole's economic reality test. Wage theft. Employers who fail to pay required wages may face civil penalties and lawsuits under state and federal laws. State versus federal compliance. Companies must comply with both federal and state labor laws, meaning they must meet the higher standard where state laws provide stronger worker protections. Option B is incorrect because state labor laws often provide greater protections and companies must comply. Option C is incorrect because independent contractor misclassification can lead to penalties. Option D is incorrect because arbitration clauses do not exempt companies from compliance obligations. Question 9. During a comprehensive review of a process that needs improvement, a financial institution is evaluating its anti-money laundering (AML) compliance program. Regulators have identified deficiencies in the company's procedures for monitoring suspicious transactions, reporting violations, and training employees. Given the requirements of the Bank Secrecy Act (BSA) and the USA Act, what steps must the institution take to address these deficiencies and avoid penalties? A. Implement risk-based AML program, improve transaction monitoring, conduct employee training, and report suspicious activities as required by law. B. Only report suspicious transactions if they exceed $100,000, as lower amounts do not require reporting. C. AML regulations apply only to banks, so non-bank financial institutions are not required to monitor transactions. D. As long as the institution does knowingly engage in money laundering, it is not required to report suspicious activity. Answer A. Implement a risk-based AML program, improve transaction monitoring, conduct employee training, and report suspicious activities as required by law. Explanation. The Bank Secrecy Act (BSA) 31 U.S.C. SSS 5311, 5330, and 8 USA Act 2001 require financial institutions to implement anti-money laundering (AML) programs to detect and prevent illicit financial activities. Key requirements include risk-based AML program. Institutions must assess risks, implement controls, and conduct regular audits. Transaction monitoring. Banks and financial institutions must detect, report suspicious transactions through suspicious activity reports (SARS) to FinCEN Financial Crimes Enforcement Network. Training employees. Financial institutions must conduct ongoing AML training for staff. Compliance with reporting thresholds. Transactions over $10,000 must be reported using Currency Transaction Report (CRS). Option B is incorrect because the reporting threshold is $10,000, not $100,000. Option C is incorrect because non-bank financial institutions, e.g., casinos, real estate firms, must comply with MR laws. Option D is incorrect because intent is not required for reporting obligation. Institutions must report any suspicious activity. Question 10. When developing a solution that must address opposing needs, a pharmaceutical company is facing regulatory scrutiny over its drug pricing practices. Consumer advocacy groups argue that the company is engaging in price gouging for essential medications, while the company insists that high prices reflect research and development costs. What legal and ethical considerations should be taken into account under U.S. drug pricing laws? A. The company must comply with federal drug pricing regulations, avoid antitrust violations, and ensure transparency in pricing decisions. B. Drug manufacturers have no obligation to justify their pricing decisions as long as they operate within free market principles. C. As long as the company holds patents, it can set any price for its medications without regulatory concerns. D. Regulatory agencies cannot intervene drug pricing decisions unless the company engages in price fixing with competitors. Answer A. The company must comply with federal drug pricing regulations, avoid antitrust violations, and ensure transparency in pricing decisions. Explanation: the Federal Trade Commission (FTC), the Food and Drug Administration (FDA), and the Centers for Medicare and Medicaid Services (CMS) oversee various aspects of drug pricing and competition. Price gouging. While no federal law explicitly prohibits price gouging, state and congressional investigations have targeted companies that increase prices excessively on essential drugs. Patent and antitrust concerns. The Hatch-Waxman Act and antitrust laws prevent companies from abusing patents to block generic competition. Medicare and Medicaid pricing. Drug manufacturers must comply with federal rebate programs under Medicaid Drug Rebate Program (WRP) and 340 Drug Pricing Program. Option B is incorrect because pricing transparency is increasingly regulated. Option C is incorrect because patents do not provide absolute pricing power without regulatory limits. Option D is incorrect because regulatory agencies can intervene under antitrust and public health laws. Question 11. When evaluating a scenario where unexpected challenges arise, a major retail corporation discovers that a cybersecurity breach has exposed customer payment data. The company must act swiftly to mitigate legal, financial, and reputational damage. Given U.S. data protection laws such as the Gramm-Leach-Bliley Act (GLBA) and state-specific breach notification laws, what immediate steps should the company take? A. Notify affected customers, regulators, and law enforcement and implement stronger cybersecurity measures. B. Wait until the full scope of the breach is determined before informing customers to avoid unnecessary panic. C. Since the breach was caused by a third-party vendor, the company is not responsible for notifying customers. D. As long as the company reimburses affected customers, it is not legally required to take further action. Answer A. Notify affected customers, regulators, and law enforcement and implement stronger cybersecurity measures. Explanation: the Gramm-Leach-Bliley Act (GLBA) 15 U.S.D. SSS 6801. 6827 and various state data breach notification laws require companies to take immediate action when handling customer data breaches. Breach notification requirements. Companies must notify affected customers, regulatory authorities, and in some cases, law enforcement. Mitigation measures. The company must implement cybersecurity improvements to prevent further breaches. Third-party responsibility. Under laws like California's Consumer Privacy Act (CCPA), businesses remain responsible for breaches even if caused by third-party vendors. Legal and financial repercussions. Failure to comply can result in hefty fines, lawsuits, and reputational damage. Option B is incorrect because many laws require prompt notification, not waiting for full investigation results. Option C is incorrect because companies are responsible for breaches involving third-party vendors. Option D is incorrect because reimbursement does not remove the company's legal obligations. Question 12. During a critical decision-making process that impacts operations, a hospital is struggling with compliance issues regarding patient privacy and electronic health records (ER). Under HIPAA, what steps must the hospital take to ensure compliance and avoid legal penalties? A. Implement strict access controls, conduct employee training, encrypt patient data, and report breaches as required. B. Only restrict access to AIs for patients who explicitly request privacy protections. C. As long as doctors and nurses follow internal guidelines, HIPAA violations will not result in fines. D. HIPAA only applies to large hospitals, so smaller healthcare facilities are exempt from compliance. Answer A. Implement strict access controls, conduct employee training, encrypt patient data, and report breaches as required. Explanation: the Health Insurance Portability and Accountability Act, HIPAA 42 U.S.C. SS 1320, establishes privacy and security requirements for protected health information. 5. Access controls: hospitals must restrict access to patient data using authentication methods, encryption, and cybersecurity. Electronic health records AIs must be encrypted to prevent unauthorized access. Employee training: staff must undergo regular HIPAA training to ensure compliance. Breach reporting: under the breach notification rule, hospitals must notify patients and regulators of data breaches. Option B is incorrect because HIPAA applies to all patients, not just those requesting privacy. Option C is incorrect because violations can result in heavy fines even if unintentional. Option D is incorrect because HIPAA applies to all healthcare providers, regardless of size. Question 13. In a situation requiring negotiation between conflicting interests, a labor union and a manufacturing company are at an impasse over contract negotiations. What legal obligations must both parties adhere to under the National Labor Relations Act? A. Engage in good faith negotiations, allow collective bargaining rights, and adhere to National Labor Relations Board (NLB) rulings. B. The company can refuse to negotiate and impose unilateral decisions. C. Strikes are illegal unless pre-approved by the employer. D. The union can demand contract terms without compromise. Answer A. Engage in good faith negotiations, allow collective bargaining rights, and adhere to National Labor Relations Board (NLB) rulings. Explanation: the National Labor Relations Act (LRA 29 U.S.C.) SSS 151-169 protects employee rights to unionize and engage in collective bargaining. Good faith bargaining: employers and unions must negotiate in good faith. NLB oversight: the National Labor Relations Board (NLB) resolves labor disputes. Right to strike: employees can legally strike, though certain conditions, e.g. no strike clauses, may apply. Employer limitations: employers cannot refuse negotiate or retaliate against union activity. Option B is incorrect because employers must negotiate in good faith. Option C is incorrect because strikes do not require employer approval. Option D is incorrect because negotiations require compromise from both sides. Question 14. When analyzing a complex financial scenario, an investment firm is suspected of insider trading. What actions must the firm take to comply with SEC regulations? A. Conduct an internal investigation, cooperate with regulators, and enforce strict compliance policies. B. Ignore the allegations unless there is a formal lawsuit. C. Insider trading is only illegal if profits exceed $1 million. D. As long as information was obtained legally, employees can trade on it. Answer A. Conduct an internal investigation, cooperate with regulators, and enforce strict compliance policies. Explanation: insider trading laws, Securities Exchange Act of 1934, SEC Rule 10.5 prohibit the use of material non-public information (MPI) for trading. Internal investigation: the firm must investigate suspected violations. Regulatory cooperation: firms must cooperate with the SEC and Dutch compliance policies. Companies must implement strict training and monitoring. Option B is incorrect because ignoring allegations can lead to penalties. Option C is incorrect because insider trading is illegal regardless of profit size. Option D is incorrect because legally obtained information does not remove insider trading restrictions. Question 15. During a risk assessment for business continuity planning, a logistics company faces supply chain disruptions due to geopolitical conflicts. What steps should it take to minimize financial and operational risks? A. Diversify suppliers, establish contingency plans, and comply with trade regulations. B. Wait for government intervention before making changes. C. Raise prices on all goods to offset losses. D. Eliminate supplier contracts in affected regions immediately. Answer A. Diversify suppliers, establish contingency plans, and comply with trade regulations. Explanation. Supply chain risk management is critical in industries affected by geopolitical instability. Supplier diversification. Companies should avoid reliance on single suppliers in unstable regions. Contingency planning. Developing alternative logistics routes and inventory reserves helps mitigate risks. Trade compliance. Companies must to export-import restrictions and sanctions. Option B is incorrect because proactive measures are necessary. Option C is incorrect because raising prices alone does not solve supply chain issues. Option D is incorrect because immediate contract cancellations can create legal and financial consequences. Question 16. When evaluating a scenario where unexpected challenges arise, a multinational technology company faces an antitrust investigation for allegedly monopolistic practices. Under U.S. antitrust laws, what key legal defenses could the company use to justify its market position? A. Demonstrating consumer benefits, competition from alternative firms, and adherence to fair pricing practices. B. Arguing that as a dominant company, it has the right to set market conditions without interference. C. Claiming that competitors are too small to challenge its market dominance, so no regulation is needed. D. Ignoring the investigation as long as there is no direct financial penalty imposed. Answer A. Demonstrating consumer benefits, competition from alternative firms, and adherence to fair pricing practices. Explanation. U.S. antitrust laws, including the Sherman Act 1890, Clayton Act 1914, and Federal Trade Commission (FTC) Act 1914, prohibit anti-competitive behaviors such as price fixing, monopolization, and exclusionary practices. Consumer welfare defense. If a company can prove that its dominance benefits consumers through low prices and innovation, it may have a legal defense. Market competition analysis. Courts can whether other competitors exist in the market, pricing and business practices. If the company follows fair pricing practices and does not use exclusionary tactics, it may not be violating antitrust laws. Option B is incorrect because market dominance alone is not illegal, but using it to eliminate competition is. Option C is incorrect because competitor size is not a valid legal defense. Option D is incorrect because ignoring an antitrust investigation can lead to severe penalties. Question 17. During a critical decision-making process that impacts operations, an airline must decide how to handle a major cybersecurity attack that has grounded flights. Under federal aviation regulations, what immediate actions should the airline take to restore operations and ensure compliance? A. Implement emergency response protocols, notify authorities, and secure its systems. B. Delay all public announcements until the airline determines the full extent of the breach. C. Rely on external cybersecurity firms without involving government regulators. D. Ignore minor system breaches as long as flights can still operate manually. Answer A. Implement emergency response protocols, notify authorities, and secure its systems. Explanation. Under FAR regulations, the Cybersecurity Information Sharing Act (CISA) and SAR cybersecurity directives, airlines must take immediate action when dealing with cyber threats. Emergency response. Airlines must follow FAR-mandated cybersecurity response plans to minimize operational disruptions. Government notification. The airline report the incident to FAR, SAR, and CISA to assess national security risks. Its system security, immediate patching of vulnerabilities, and multi-layered security measures are required. Option B is incorrect because delaying public disclosure can lead to regulatory penalties. Option C is incorrect because government agencies must be involved in aviation cybersecurity. Option D is incorrect because even minor breaches can escalate into major threats. Question 18. In a situation requiring negotiation between conflicting interests, a pharmaceutical company is in talks with regulatory agencies over the pricing of a life-saving drug. How should the company balance profitability and public health concerns? A. Offer tiered pricing models, provide transparency on costs, and collaborate with government agencies. B. Set the highest possible price to maximize shareholder profits, regardless of public reaction. C. Delay negotiations until legal challenges arise from public advocacy groups. D. Refuse to negotiate since the company owns the exclusive patent rights. Answer A. Offer tiered pricing models, provide transparency on costs, and collaborate with government agencies. Explanation. The FDA, FTC, and Medicare/Medicaid regulations impact drug pricing and require companies to balance affordability with profitability. Tiered pricing Companies can offer different pricing structures based on market and patient needs. Cost transparency, disclosing research and development, R&D cost, justify pricing decisions. Government collaboration, working with Medicare, Medicaid, and global health agencies ensures broader accessibility. Option B is incorrect because excessive pricing can lead to government intervention and lawsuits. Option C is incorrect because delaying negotiations can result in negative publicity and regulatory penalties. Option D is incorrect because even patent holders must comply with fair pricing regulations. Question 19. When analyzing a complex financial scenario, an investment bank faces accusations of fraudulent misrepresentation in selling high-risk securities. What legal standards must it adhere to in resolving the issue? A. Comply with SEC regulations, disclose risks transparently and offer restitution to affected investors. B. Deny responsibility and challenge all allegations in court. C. Only adjust sales practices if a lawsuit is filed. D. Claim that as long as no laws were intentionally broken, no action is needed. Answer A. Comply with SEC regulations, disclose risks transparently, and offer restitution to affected investors. Explanation: the Securities Act of 1933 and the Securities Exchange Act of 1934 regulate investment disclosures and fraud prevention. Full disclosure: the SEC requires investment firms to disclose material risks in securities sales. Restitution requirements: firms must compensate investors for missed financial statements. Regulatory compliance: SEC investigations can lead to civil and criminal penalties. Option B is incorrect because ignoring fraud allegations can worsen legal consequences. Option C is incorrect because proactive compliance is necessary even without lawsuits. Option D is incorrect because unintentional fraud is still punishable under securities laws. Question 20. During a risk assessment for business continuity planning, a global supply chain company faces rising fuel prices and transportation delays. What strategies should it implement to mitigate financial risks? A. Diversify suppliers, invest in alternative transportation methods, and negotiate long-term contracts. B. Increase service fees without making operational changes. C. Wait for fuel prices to stabilize before adjusting business strategies. D. Eliminate supplier contracts with regions experiencing delays. Answer A. Diversify suppliers, invest in alternative transportation methods, and negotiate long-term contracts. Explanation: logistics risk management requires proactive measures to handle economic and geopolitical disruptions. Supplier diversification, reducing dependency on single-source suppliers, improves resilience. Alternative transportation: companies should explore rail, shipping, and electric vehicles to reduce fuel dependency. Negotiations: locking in long-term fuel pricing contracts can provide cost stability. Option B is incorrect because raising fees without efficiency improvements reduces competitiveness. Option C is incorrect because waiting for price stability increases financial uncertainty. Option D is incorrect because eliminating suppliers without alternatives disrupts operations. Question 21. When evaluating a scenario where unexpected challenges arise, a multinational corporation faces a major data breach exposing customer financial records. What immediate actions should the company take to mitigate legal, financial, and reputational damage? A. Notify affected customers, report the breach to regulators, and strengthen cybersecurity measures. B. Deny the breach until external investigations confirm it. C. Minimize disclosure to avoid regulatory scrutiny. D. Wait for a public relations crisis before responding. Answer A. Notify affected customers, report the breach to regulators, and strengthen cybersecurity measures. Explanation: data protection laws, including the General Data Protection Regulation (GDPR) and the U.S. Data Breach Notification laws, require companies to act swiftly in case of a breach. Customer notification: companies must immediately inform affected customers to minimize financial risks like fraud or identity theft. Regulatory reporting: in many jurisdictions, breaches must be reported to government agencies within a set time frame. Cybersecurity improvements: implementing multi-factor authentication, encryption, and detection helps prevent future breaches. Option B is incorrect because delaying acknowledgement erodes customer trust and increases legal liability. Option C is incorrect because hiding breach details violates compliance laws. Option D is incorrect because companies must be proactive, not reactive. Question 22. During a critical decision-making process that impacts operations, a global retailer must determine how to handle supply chain disruptions caused by geopolitical conflicts. What strategies should it implement to maintain product availability? A. Diversify supplier sources, increase local production, and invest in predictive analytics. B. Accept losses and wait for the situation to stabilize. C. Pass all cost increases directly to consumers. D. Stop importing goods from affected regions without alternative solutions. Answer A. Diversify supplier sources, increase local production, and invest in predictive analytics. Explanation: supply chain risk management requires companies to anticipate disruptions and develop resilient strategies. Supplier diversification, reducing reliance on a single country or supplier, lowers exposure to risks. Local production investment, manufacturing closer to demand centers ensures stability. Predictive analytics, data forecasting helps anticipate and mitigate disruptions. Option B is incorrect because waiting without action worsens financial impact. Option C is incorrect because passing all costs hurts consumer trust. Option D is incorrect because stopping imports without alternatives creates shortages. Question 23. When analyzing a complex financial scenario, a publicly traded company faces declining stock prices due to economic downturns. What financial strategies should it implement to maintain investor confidence? A. Enhance transparency, optimize cost structures, and communicate long-term growth plans. B. Disregard investor concerns and focus only on internal operations. C. Make aggressive acquisitions to offset losses. D. Avoid financial disclosures to prevent panic. Answer A. Enhance transparency, optimize cost structures, and communicate long-term growth plans. Explanation: investors seek clarity and stability in economic downturns. Transparency, regular financial reports and clear earnings guidance build trust. Cost optimization, reducing non-essential expenses without sacrificing growth is key. Long-term vision, clear growth strategies reassure shareholders. Option B is incorrect because ignoring investors reduces stock confidence. Option C is incorrect because risky acquisitions may worsen financial instability. Option D is incorrect because lack of disclosure damages credibility. Question 24. In a situation requiring negotiation between conflicting interests, an automaker faces government pressure to accelerate its electric vehicle EV production. How should the company balance regulatory demands with financial constraints? A. Develop a phased transition plan, secure government incentives, and invest in R&D. B. Immediately halt gasoline car production without financial assessments. C. Delay production until competitors succeed first. D. Reject regulatory demands due to short-term profitability concerns. Answer A. Develop a phased transition plan, secure government incentives, and invest in R&D. Explanation: automakers must balance compliance, financial sustainability, and innovation. Phased transition, a gradual shift allows for cost management. Government incentives, tax credits reduce R&D expenses. Innovation investment, funding battery and manufacturing advancements improves competitiveness. Option B is incorrect because abrupt changes risk financial instability. Option C is incorrect because delaying causes market share losses. Option D is incorrect because non-compliance leads to regulatory fines. Question 25. When managing a high-stakes project with tight deadlines, a construction firm faces material shortages due to global supply chain issues. What proactive measures should the firm take? A. Secure alternative suppliers, adjust project timelines, and explore sustainable materials. B. Continue operations as planned and hope shortages resolve. C. Ignore supplier contracts and seek legal action for non-compliance. D. Reduce material quality to maintain deadlines. Answer A. Secure alternative suppliers, adjust project timelines, and explore sustainable materials. Explanation: effective project management requires adaptability. Alternative suppliers, establishing multiple sourcing channels ensures continuity. Timeline adjustments, managing stakeholder expectations reduces disruptions. Sustainability focus, exploring recyclable or alternative materials can create long-term benefits. Option B is incorrect because inaction delays projects further. Option C is incorrect because legal action doesn't solve immediate material needs. Option D is incorrect because lowering quality harms reputation and compliance. Question 26. During a leadership transition in a major corporation, the newly appointed CEO must address employee concerns over restructuring. What approach should they take? A. Communicate the vision clearly, provide support programs, and involve employees in the process. B. Make sudden changes without employee input. C. Avoid addressing concerns to maintain authority. D. Lay off employees without transparent explanations. Answer A. Communicate the vision clearly, provide support programs, and involve employees in the process. Explanation. Effective leadership transitions require clarity, inclusion, and stability. Clear vision. Employees must understand the company's direction. Support programs. Offering reskilling, counseling, and financial support eases transition fears. Employee involvement. Gain feedback on changes builds trust. Option B is incorrect because abrupt decisions lower morale. Option C is incorrect because ignoring concerns creates uncertainty. Option D is incorrect because layoffs without transparency harm the employer brand. Question 27. When evaluating a scenario where unexpected challenges arise, a pharmaceutical company experiences delays in FDA approval for a new drug due to additional clinical trial requirements, what steps should the company take to address the situation while maintaining investor and consumer confidence? A. Enhance communication with the FDA, allocate resources to meet new requirements, and keep stakeholders informed. B. Challenge the FDA's decision legally and refuse to conduct further testing. C. Shift focus to another product and abandon the delayed drug. D. Withhold information from investors until the issue is resolved. Answer A. Enhance communication with the FDA, allocate resources to meet new requirements, and keep stakeholders informed. Explanation. Regulatory challenges require proactive and transparent responses to maintain trust and progress. Engaging with the FDA. Direct communication helps clarify regulatory concerns and identify pathways to approval. Resource allocation. Dedicating additional research funds ensures compliance with trial requirements. Stakeholder transparency. Keeping investors and consumers informed prevents speculation and loss of confidence. Option B is incorrect because legal battles prolong approval and strain relationships. Option C is incorrect because abandoning the drug wastes previous investments. Option D is incorrect because hiding information violates corporate ethics and damages credibility. Question 28. During a critical decision-making process that impacts operations, a global airline must determine how to respond to rising fuel prices without significantly increasing ticket costs. What strategies should the airline implement? A. Optimize flight routes, invest in fuel-efficient aircraft, and introduce revenue-generating services. B. Immediately raise ticket prices without evaluating alternatives. C. Reduce staff salaries and benefits to compensate for fuel costs. D. Cut back on maintenance expenses to lower operational costs. Answer A. Optimize flight routes, invest in fuel-efficient aircraft, and introduce revenue-generating services. Explanation. Effective cost management requires a balanced approach that doesn't compromise customer experience or safety. Flight route optimization. Using data analytics to identify fuel-efficient paths can significantly reduce costs. Fuel-efficient fleet investments. Modern aircraft with better fuel economy provide long-term new revenue streams. Adding premium services, cargo operations, or in-flight offerings can offset increased fuel expenses. Option B is incorrect because immediate price hikes hurt competitiveness. Option C is incorrect because reducing salaries lowers employee morale and retention. Option D is incorrect because cutting maintenance increases safety risks and regulatory violations. Question 29. When analyzing a complex financial scenario, a major retailer must decide how to handle declining sales due to changing consumer preferences. What financial strategy should it adopt to remain competitive? A. Expand commerce presence, personalize marketing strategies, and enhance product diversification. B. Ignore market trends and continue with the same business model. C. Reduce customer service staff to cut costs. D. Discontinue underperforming stores without exploring restructuring options. Answer A. Expand commerce presence, personalize marketing strategies, and enhance product diversification. Explanation. Adapting to consumer behavior requires strategic investments and market analysis. E-commerce expansion. Developing a strong online presence captures digital shoppers. Personalized marketing, AI-driven recommendations, and loyalty programs improve customer retention. Product diversification. Offering new product categories aligned with emerging trends increases appeal. Option B is incorrect because ignoring trends leads to further losses. Option C is incorrect because cutting customer service reduces brand loyalty. Option D is incorrect because restructuring may offer cost-effective turnaround solutions. Question 30. In a situation requiring negotiation between conflicting interests, a tech company faces backlash from employees after announcing a return-to-office policy. How should leadership address concerns while maintaining productivity? A. Implement a hybrid work model, gather employee feedback, and invest in office collaboration tools. B. Enforce strict in-office attendance without exceptions. C. Ignore employee concerns and maintain a top-down decision-making approach. D. Eliminate remote work positions entirely to force compliance. Answer A. Implement a hybrid work model, gather employee feedback, and invest in office collaboration tools. Explanation. Balancing organizational goals and employee needs is key to maintaining productivity and morale. Hybrid model implementation. Offering flexible work options satisfies both business and employee needs. Employee engagement. Regular feedback loops ensure policies align with workforce preferences. Collaboration investments. Providing remote-friendly tools, video conferencing, cloud access enhances efficiency. Option B is incorrect because strict policies may cause employee dissatisfaction and resignations. Option C is incorrect because ignoring feedback creates internal conflict. Option D is incorrect because eliminating remote roles reduces access to a wider talent pool.